Norton. I'm the Deputy Monitoring Officer and Assistant Director Legal at North Yorkshire Council, and I am going to be talking today about the role and responsibilities of the Monitoring Officer in local government. And what we're looking to do is to provide some practical advice for monitoring officers, their deputies, or anyone who is interested in the role. The role is becoming increasingly important, complex and challenging, given the requirement to navigate through all of the change that we're seeing in local government at the moment. And that may be the case, especially for some of you who had elections to your local authorities last Thursday. And so, as I say, there's lots of change to navigate, and our role as monitoring officers is to make sure our governance is correct and fits that change, whether that change be structural change following local government reorganisation and new models of devolution, whether it be political change. Like I say, a number of you may well have been through elections last week, and undoubtedly we're all operating in an increasingly charged political environment and seeing new political groups and allegiances forming, and the rise of independence, and also possibly some councillors that have very limited local government knowledge and experience. We're also seeing financial change in what seems to have been a period of ongoing austerity. There are lots of difficult decisions to be made, services being reviewed, and those types of decisions are always prone to challenge. So the monitoring officer's involvement in them and making sure that they're following the correct and lawful process is key. And also, as part of the financial challenge, I'm aware that monitoring officers are increasingly being asked for advice about local authority companies which have been set up to carry out commercial activity. And then finally, technology change. We've seen the impact of social media for a number of years now, in terms of it meaning that political debate and campaigns are much more visible, and things can gain traction more quickly and attract public and media attention. But now we're also seeing the rise of AI, and so the technologies out there to write pre-action protocol judicial review letters. And also, I think there's a greater awareness now through AI of what the role of the monitoring officer is. And I'll come on to touch upon the trend that we're seeing, which is complainants contacting the monitoring officer direct and asking them to intervene using their Section 5 duty. So all of that change is why we have an image of a superhero on our opening slide to this presentation, because the role has expanded significantly and it is demanding. Not only do you need a strong understanding of the law and procedure, strong political acumen, you need resilience and leadership, and I think I'm certainly of the view you need a good sense of humour as well. So if we could move to the next slide. You'll probably all be familiar or aware that the monitoring officer is a statutory role, which was created by Section 5 of the Local Government and Housing Act 1989, which requires every local authority to designate an officer as the monitoring officer who is responsible for performing specific duties. The monitoring officer is one of the trinity of statutory officers, the other two being the head of paid service and the chief finance officer, or Section 151 officer, as they're often referred to. Moving on to the next slide. The primary duty is to appoint someone as the monitoring officer. Now, that someone cannot be the authority's chief finance officer, but it can be their head of paid service. And in terms of who is an officer, the court has held that an officer need not be an employee of the authority. So you can designate the employee of a contractor or of another authority to be your monitoring officer. Up on the slide, you'll see that there's reference to some standing order regulations. They provide that if you're not appointing or proposing to appoint a monitoring officer exclusively from amongst your existing officers, then there's a requirement to advertise the role. And the appointment of a monitoring officer is a non-executive function. I think the thing that some find surprising is that full council doesn't need to make the decision to appoint or who to appoint. They can delegate that decision down to a committee or even to an individual officer. But frequently you will find that the constitution of an authority actually reserves the function to full council. And it's also important to note that only one officer can be designated as the monitoring officer at any one time. In terms of resources and deputies on the next slide, then the legislation makes it clear that the authority must provide the designated monitoring officer with such staff accommodation and other resources are, in the monitoring officer's opinion, sufficient to allow those duties to be performed. And that's to ensure that monitoring officers have adequate support to discharge their functions effectively. Now, in current financial circumstances, as a monitoring officer, you may well feel you have to remind others of this, albeit that message is unlikely or may well not be well received. So only use it as a last resort. And remember that as monitoring officer, it's your opinion that counts as to what is adequate. The next point is that the statutory role of monitoring officer has to be carried out by them personally. But if they're unavailable due to absence or illness, then they can arrange for it to be carried out by a deputy monitoring officer. The deputy monitoring officer must be a member of the monitoring officer's staff, so someone that reports to them, which, if you think about it, is logical and common sense. On the next slide, there's a summary here of what those core responsibilities or statutory duties of a monitoring officer are. And the first one is the duty to report, where the monitoring officer is of the opinion that there has been an unlawful act or maladministration. The second one is around member conduct, and there's a range of functions relating to member conduct. And then the third one is around maintaining and updating the constitution, and also it's likely that the monitoring officer will be named as proper officer for a number of specific functions in the constitution. So we'll be going on to focus on each of those three areas and those three core duties of the monitoring officer during this presentation. It's very likely, however, that the monitoring officer is going to have a number of other duties, including being the legal advisor to the authority, may well have a role in relation to corporate complaints or audit investigations and whistleblowing. They have an overlap and are likely to link in with the monitoring officer reporting duty. And also, one of the monitoring officer's key day-to-day roles is around protecting decision-making to avoid the need to go and make those formal reports, which we'll come on to. So looking at section 5, duty to report, and the wording from the sections up here in terms of the monitoring officer having a duty to prepare a report to the authority where it appears that any proposal, decision or omission constitutes a contravention by the authority of any enactment or rule of law or gives rise to maladministration or failure, as referenced in that particular part of the Local Government Act. So breaking that down a little bit, on the next slide, what is it that triggers the monitoring officer duty to report? So on this next slide, you can see that it says, if at any time it appears to him. So it's a personal duty and shows that the monitoring officer must have sufficient oversight of decisions or have officers who can flag and escalate any potential issues. So that's the first thing. If we could have the next slide, please. It says any proposal, decision or omission. So a proposal is more than just a vague idea, and it might be that as monitoring officer, you can form the view that something's at a very formative stage, it's not likely to go anywhere, and therefore it's not going to be triggering your duty to report it. And then it talks about, in the section, the proposal or decision by any committee or any person holding office or employment. Well, that's pretty comprehensive. However, it's worth noting that it doesn't cover partnership bodies or local authority companies unless the local authority nominee on that body acts unlawfully in their capacity as local authority office holder. The next point to note around the wording in section 5 is it says has given rise to or is likely to give rise to. So likely, you probably apply a test such as on the balance of probability. Is it likely to give rise to a contravention? So contraventions, I think we all know that in some cases the law can be finely balanced. So it's a judgment exercise, and it's your view as monitoring officer as to whether or not there has been a contravention, infringement of the law. And then finally, it talks about any such maladministration or injustice, and the local government ombudsman has conducted an investigation. So for maladministration, there has to have been an investigation before your duty to report is triggered. So looking at the report itself, the monitoring officer must, so far as practicable, consult the head of paid service and the chief finance officer. It's worth noting there is a potential overlap with the monitoring officer duties and duties that the chief finance officer has under section 114 of the Local Government Finance Act 1988. The chief finance officer has a duty to report on unlawful decisions, actions which are unlawful and likely to cause a loss or deficiency, or an unlawful item of account. So the chief finance officer's duty can easily be engaged in a monitoring officer report, and the chief finance officer will want to think about whether they want to involve the external auditor. Now, in terms of consultation, it means just that. It doesn't mean that when you consult with them as monitoring officer, you have to have the agreement of the head of paid service or the chief finance officer before you take a report. They don't have any powers of veto. You've got to take their views into account, and we'd recommend that you could record whatever it is that their view is, especially if they disagree. It'll be important to make a note of the reasons why. When it comes to making the report, then if the proposal was or is made on behalf of the executive, and so you're in an authority that operates executive arrangements, then the report must be addressed to the executive under section 5A. Otherwise, it's to full council under section 5. The report's got to go to all members of the authority, and the council or the executive, depending on who the reports to, have got to meet within 21 days to consider the report. The implementation of the proposal or decision in question is suspended in the meantime, and it's suspended until 2 business days after that meeting. If we could just go back a few slides, we're just racing ahead a little bit. Thank you. Just back one more. That's lovely. Thank you. And then if the report's to the executive, then the executive has to make a report, its own report, saying what action it's taken or proposes to take and the reasons and therefore, and they have to send it to all members. So moving on to the next slide, drafting the report. Up here on this slide says what the report should contain. Again, most of it is fairly much common sense in that the report should start by describing the monitoring officer's duty, set out the circumstances giving rise to why the report's been made and why the duty is engaged. It should explain what this process is and the consequences of the monitoring officer reporting, so the duty of members to consider it, the fact that the action or decision implementation of the decision has been suspended, and if it's an executive decision and a report to the executive, the obligation on the executive to prepare a report in response. As monitoring officer, you might want to refer to members' obligations under the Code of Conduct, if that sets out and provides that members have got to have regard to the monitoring officer or legal advice. And you may also want to set out in the report anything that's been done to date to try and mitigate the consequences of the decision or action. And then finally, it's usual that the monitoring officer makes recommendations seeking to rectify or note or avoid it from happening again. Now, the usual rules around timetable, notice and publicity and exempt information will apply for your Section 5 report. If parts of the report are exempt, then especially where it's a controversial or sensitive report, which by its nature it will be, it's always better to try and explain the reasons why the exemption applies and to set those out in full. So moving on now to the next slide, to report or not to report. Well, there are two approaches to the duty to report. There's a literal reading of Section 5, which would cause us as monitoring officers to be making regular reports in every minor or anticipated misdemeanour or possible infringement. Or there is a more pragmatic approach, which is favoured by most monitoring officers, that you don't report unless it's very serious and there's still a problem to resolve. It's often referred to as the nuclear option, as the monitoring officer report can be received or perceived as a bombshell, and it's likely to generate adverse publicity because it very much is an assertion that something's gone wrong, either at member or officer level or both, whether that's through mistake, incompetence, or even in some cases possibly corruption. Now, the monitoring officer here has described to me that the monitoring officer report is like the emergency acts you have behind safety glass. You only break the glass in an emergency and if you're not being listened to. And I think that's a very good visual to have in mind when you're thinking about whether to issue a Section 5 report. So it is very much a judgment call, and you need to look at the risks and often seek specialist legal advice and get some backup, including counsel's opinion. Even if you know the answer and you're an experienced lawyer yourself, it's useful to be able to point to an independent opinion on something to assert that this is the correct position. Ultimately, it comes down to gut feel. So what do you think are the consequences of not reporting something and of reporting? Where does it fit in with the principles of public life? And does not reporting it fit in with those principles? So how would the public perceive it if you didn't report it and effectively sought to sweep it under the carpet? And again, coming back to those earlier points I made, you don't have to report it if it's premature because it's not yet a proposal. And so it's possible that you might head it off at the pass before it comes to the stage where you need to report it. And you don't need to report it if it's not unlawful. And that comes back to that point I made about finely balanced legal arguments. And bearing in mind that a decision is presumed lawful as a matter of administrative law, unless and until proved otherwise. As I said before, we are definitely seeing a trend where service complaints and service complainants are now contacting the monitoring officer directly, asking the monitoring officer to intervene in their complaints and quoting the Section 5 duty. So what we have done here is we've developed a standard response to those AI statements, which explains that individual service-related concerns are considered through the corporate complaints process, which is the proper channel, And as part of that process, officers considering complaints can link in with lawyers in legal services as required regarding any legality and governance issues before responses are made. And if there are any legal concerns, then at that stage they can be raised by the legal officer at the council with the monitoring officer. And so the message is very much that it's for the monitoring officer to decide whether or not their Section 5 duties engaged, not for the complainant to determine that. So just moving on to the next slide, a couple of recent examples up here of Section 5 reports from the back end of last calendar year. In Peterborough, there was a joint report from both the monitoring officer and Section 151 officer concerning the council's historic disposal of land and buildings known as the John Mansfield Centre and a number of associated financial transactions. Basically, there was a clear breach of the duty to obtain best consideration under Section 123 of the Local Government Act. More particularly, at the time of disposal, the John Mansfield Centre, the book value was 4.6 million and it was transferred at £1. So clearly not at the best consideration reasonably obtainable, and it should have had Secretary of State consent given the undervalue of the property exceeded that 2 million in the general disposal's consent. There was no evidence of any attempt to seek such consent of the Secretary of State, and nor was there a subsidy control assessment. So the statutory officers jointly recommended a number of things. They took a Section 5 report and they recommended members noting the details of the report, that there's a comprehensive review of processes, that an external provider was engaged to deliver additional training to officers and members around best consideration, and that the monitoring officer continued to explore all feasible avenues of legal redress in relation to the unlawful disposal of the property. And there was information about an ongoing criminal investigation and a requirement to conduct a comprehensive review of all relevant policies and procedures and aspects of the Constitution. So that was Peterborough. Many of you may have come across the monitoring officer at Warwickshire District Council, who issued a Section 5 report, again at the back end of last year, over the way in which the local authority applied a second home's council tax premium, and in particular the failure to have consideration to the government guidance and the fact that there was no clear statement of intention as to the exact percentage of premium that would be applied in any of the cabinet or council resolutions. So those are just two recent examples, and that's the duty to report. Moving on to the next slide now, and looking at the monitoring officer's governance role and the Constitution. So you're probably all familiar with the fact that the local authority is under a duty to prepare and keep up to date its constitution under the Local Government Act. And there are a number of things that as a minimum the Constitution must contain. They include standing orders, procedural rules, the members' code of conduct, and such information as the Secretary of State may direct, and other information that the individual authority considers as appropriate. Moving on to the next page, the Constitution is really a locally driven document which should reflect the character and culture of your organisation, and it's there to facilitate council business. So keeping it under regular review as monitoring officer helps ensure it's fit for purpose, and importantly that those who read it can understand it, including members of the public who might want to participate in council business by asking questions at meetings or making representations. So it will need to cover a number of things, all of which I've put up on this slide, around structure and allocations of functions and decision making. Things that are worth looking out for and keeping under review are clarity over what comprises the budget and policy framework. And a number of you, if you've just been through an election and you've got a change in administration or something in no overall control, you may find that that your new administration are wanting to take decisions which are out with the existing budget and policy framework, and it will take a while to update that framework. So again, it's being familiar with what the procedures are in your constitution around taking decisions out with the budget and policy framework. It's also worth keeping the limits for key decisions under review to check that they are appropriate in today's environment. And also checking that your officer structure and is up to date, and that there's a clear process for explaining member decision making. So that's just a quick whistle-stop tour of the Constitution and the role of the monitoring officer. Moving now on to the final area, which is member conduct. And the monitoring officer functions relating to member councillor conduct come under the Localism Act 2011. And broadly speaking, there are three areas. One is around maintaining a register of interest for councillors. The second is considering and, where appropriate, arranging for the investigation of complaints that councillors have acted in breach of the code of conduct. And then finally, the role of supporting councillors and complainants when it comes to member conduct. So on the next slide, again, looking at what the legislation says, on the next slide, please. What the legislation says is the core duty, and it's there in section 27 of the Localism Act. It's to promote and maintain high standards of conduct by members and co-opted members, and when discharging this duty, to adopt a code dealing with the conduct that is expected of members and co-opted members of the authority when they're acting in their capacity. So that's in their official capacity as councillors. On the next slide, you will see that the code of conduct has to be consistent with the 7 principles of public life set out in the first report of the Nolan Committee on Standards in Public Life, which are selflessness, integrity, objectivity, accountability, openness, honesty, and leadership. On to the next slide. The code must also contain provisions about registers of interest, both pecuniary and other interests. At the bottom there, you'll see that I've referenced the Model Code of Councillor Conduct. The Local Government Association has produced a Model Code and extensive guidance and training materials to accompany it. I'm not going into the individual provisions of the code today because of time, but certainly the LGA's website is a good starting point and has lots of comprehensive information. Moving on to the next slide. So parish councils. In North Yorkshire, we've got a very large geographical area, and we have about 350 parish councils in our area. So lots of parish councils and parish councillors and conduct issues due to the scale of our geography. And what the Localism Act says is that a parish council, it has to uphold this obligation around maintaining and promoting high standards of conduct, and it may adopt its the code of conduct of its principal authority in order to comply with that. Moving on to the next slide. I mentioned that one of the monitoring officer's duties when it comes to conduct is around complaints. Now, this section, section 28 of the Localism Act, requires a local authority, a relevant authority other than a parish council, to have arrangements in place to deal with complaints that its code of conduct has been breached, including arrangements for complaints to be investigated and decisions on allegations to be made. So, although under section 28(6), a district or a unitary authority are responsible for having arrangements in place to investigate and determine allegations against parish councillors, the Localism Act is silent on how that might be done, other than involving the views of an independent person, which we'll come on to independent persons in a minute. So it is certainly North Yorkshire's case a significant ask, given the volume of parish councillors that there are, to consider all complaints that come in and to determine whether or not they should be investigated. It's also worthwhile bearing in mind that the Localism Act doesn't provide any sanction for you as monitoring officer when having investigated a complaint against a parish councillor, find that there's a breach. Parish councils are not under any obligation to have regard to any findings that is made through the district or unitary authority standards process. So just moving on to the next slide, which is the role of the independent person that I mentioned has to be involved in the standards process. More particularly, their views must be sought and taken into account by the principal authority before it makes any decision on allegations that it has decided to investigate. And also, the independent person's views may be sought by the council in relation to an allegation that is decided not to investigate, and also by the subject member. What we look to do here is that we look to involve a monitoring an independent person at every stage of our process, and include their views in decision records on assessment, when matters have been investigated and when matters proceed to the panel. It's also worthwhile having more than one independent person, not just because of the volume of complaints that you may have to assess, but also if there is ever a conflict, which can arise not just through their own personal circumstances, which hopefully will not arise, given that there is a process for making sure that they are independent and who can and can't be appointed. But it's more likely if the subject member has got a right to contact the independent person contacts them, and so the subject member has taken the view of an independent person, you would then probably want to use a different independent person to sit on the panel of any investigation of that matter to determine it and give their advice. So looking at the next slide, this sets out again from the LGA guidance what the complaints process may look like. Now, there may be slight variances between your authorities in this process, but broadly speaking, the complaint has to be in writing under the Localism Act for the obligation to review it and assess it to arise. So the complaint lands, the written complaint lands, it's reviewed by you as monitoring officer with an independent person, and then you have to take a decision. First of all, is the jurisdiction, so does this complaint relate to a member whilst in their official capacity as a member? And if proven to be true, is it likely to amount to a breach of the code of conduct? And so those are the sort of filter questions that you would ask together with the independent person when assessing the complaint when it first lands. And it's also important to get on board the views of the subject member about whom the complaint is made, so that you have that when you're making that initial assessment. So that assessment's not about determining whether there has been a breach of the code, it's about determining what the appropriate next steps would be. So that might be, just going back to that flow diagram, that you decide that it's not sufficiently serious to take any formal action, and that an informal resolution such as recommending training or seeking an apology is appropriate. Or it may be that none of the jurisdiction criteria are engaged because it's nothing to do with the member acting in their official capacity. It may be that they're simply being a poor neighbour and it's them acting in their private capacity. Or it may be that it is something with which the jurisdiction criteria are engaged and it's sufficiently serious to warrant formal investigation. So if it goes forward to investigation, you'll instruct an investigating officer, who may be you as the monitoring officer, and they will then report as to whether there has been a breach of the code of conduct. And again, depending on the outcome of that investigation, there may be no further action. It may be something that's appropriate for local resolution, or it may be something that goes to a hearings panel drawn from your standards committee to determine whether there has been a breach of the code, and if so, what sanctions to recommend. So moving to the next slide, the thorny issues, as I put it, that we often come across when dealing with code of conduct complaints. The first one is jurisdiction. And we have seen, and I've seen in previous roles, a number of complaints that come in where the conduct is by an elected member, but it's not in their official capacity as a member. It's something they have done in their private life. And that might be on a social media account that they have, or it might be something that's reported by one of their neighbours. Now, the leading case on this is actually under the previous legislation, and you may well recall the complaint that was brought against Ken Livingstone in 2006 over comments he, when he was then the London mayor, made to a reporter outside County Hall, likening the reporter to a concentration camp guard. The case worked its way all the way up to the High Court, where Mr. Justice Collins found that Mr. Livingstone had not been acting in his official capacity or performing his functions as mayor at the time, and therefore it was not right to find him in breach of the code of conduct, meaning he could not, he didn't breach the code. What the High Court said was he'd effectively knocked off for the evening and no longer had his councillor's hat on. So that's the first thorny issue. One of the other thorny issues you can come across is if there's a difference in opinion between yourself and the independent person as to whether or not a complaint is something that merits investigation. Again, what you would look for is to have your standards complaints process providing for that situation. And I think it's an important safeguard that if there is any difference of opinion between the monitoring officer and the independent person, that the independent person's view effectively trumps it. So if the independent person is saying, I think this is sufficiently serious, you should investigate it, then as monitoring officer, you should be taking that on board and it being referred for an investigation. And you would expect your procedure to provide for that. The next issue I've put up is conflicts of interest. A first consideration when you decide on how an investigation is to be handled is to think about, well, are there any conflicts of interest that arise? Now, as a monitoring officer, you may have taken the decision that an allegation needs a formal investigation. That doesn't mean it's a conflict of interest if you then yourself undertake the investigation, because, you know, at that point, all you've decided is that on the face of it, there's a case to answer, but you haven't made a judgment. So an investigation is then to establish exactly what has happened and whether, in fact, it amounts to a breach of the code. So, as I say, there's no conflict in deciding that something needs investigating and then carrying out the investigation yourself. However, there are other areas where conflicts of interest may arise. So, if you were asked to investigate an allegation against a councillor and you'd already advised them on the same issue previously, regardless of whether or not they'd followed your advice, there may well be a conflict there. Also, if you've assisted or been involved in assisting the complainant in formulating their allegation, their complaint, that might create a conflict or a perception of conflict. Similarly, if you were the key, if you're a key witness or a complainant to the particular incident, you should be looking to delegate the decision and the investigation to someone else. So that's conflicts of interest. Another thing that often comes up, particularly in allegations that members have not observed the requirements around respect in the code, is Article 10 of the Human Rights Act around the freedom of expression and the right to be able to express one's political views freely, and that concern that any standards investigation and sanction in relation to that is a disproportionate interference with that right. And there's quite a lot of case law on that it's worth being familiar with when you have those types of cases. And then finally, the composition of the hearings panel. The panel should be drawn for the main body of the Standards Committee. If the panel includes independent representatives, or in our case where it's parish councillors that are having a hearing against them, we also include parish representatives, they don't have any voting rights as a matter of law. And you'll also need to be clear whether political proportionality applies to the panel, or whether that's been waived by your council, so one of those nem-con votes. And again, it's important that all panel members have undertaken suitable training. Moving on to the next slide. So tips for complaint handling. These are just some things that we do think are really important. First one is make sure you undertake the initial assessment quickly, and that you have an efficient filter mechanism to remove those complaints which do not relate to member conduct, and they do not relate to members while they're acting in their capacity as members, or ones that are just so trivial that there's no public interest or justification in expending public resources on them. I put the next one up here is stay in your lane with parish council complaints. So there's a common misconception out there that district and unitary councils are the parent authority of parish councils and are responsible for making sure that they behave appropriately and lawfully. Now, parish councils are separate legal entities. So as the district or the unitary authority, there is no ability to overrule their decisions or call them into account. The jurisdiction relates to the process of individual member conduct and making recommendations following complaints about individual members that have been investigated in a breach found. So the judicial review is a remedy in relation to parish councils, but lots of individuals, residents or electors in the area will have sufficient standing or sufficient interest to have standing, as do you as the principal authority, but there's certainly no obligation or in any way are you bound to be judicially reviewing your parish councils. So as I say, it's really important to be clear what your role of monitoring officer is and the limits of your jurisdiction when it comes to parish council complaints. It's also important in your standards procedure to be very clear about what may enter the public domain and when. So what is confidential? Your investigation process, and when, if ever, will the investigation report be released into the public domain? What are the considerations as to whether panel hearings will be held in open session or whether you'll be relying on one of the exempt sessions? What about decision notices at each stage? Are they to be made public documents or are they to be kept confidential? And then finally on this slide I've put in, it's important to have mechanisms for addressing unreasonably persistent and vexatious complaints. What you don't want to see is repeat overlapping complaints coming forward and having to go through assessment processes for the same repeated complaints time after time. There needs to be a way of effectively managing those. Moving on to the next slide, just quickly, the final area I talked about that is the monitoring officer's responsibility is member interest. So Section 29 of the Localism Act requires monitoring officers to establish and maintain a register of member and co-opted members' interests, and to make that register available for inspection and publish it on the council's website. And the monitoring officer is also required to make the register of members' interest for parish councils in the authority's area available for inspection, and again it's published on the website. Now there's specific requirements around disclosable pecuniary interests, other registrable interests, and then things that are not registrable. And there's time limits for registering interests, again, all set out in the Localism Act, and not proposing to go into the detail of that today. Dispensations, again, you'll want to look carefully as monitoring officer what the process in the Constitution is for granting dispensations, whether they have to go to the committee, they have to be written requests, or whether it's something that can be made to you as monitoring officer, and in what circumstances you would give somebody a dispensation that enables them to stay in the room and participate in the debate on the item in which they have an interest and vote. And then finally, sensitive interests. The monitoring officer has powers relating to sensitive interests under Section 32 of the Localism Act, where the nature of a member's interest is such that disclosure could lead to the member or person connected with them being subjected to violence or intimidation. And if the monitoring officer agrees, the member merely has to disclose the existence of an interest rather than the details of it at the meeting, and the detail can also be excluded from the published version of register. Now, growing concerns around member safety is happening across the country, and some authorities are having discussions as to whether members' home addresses should automatically be treated as a sensitive interest, rather than individual members making applications to the monitoring officer. Now, whilst I appreciate the pragmatic standpoint, I would say that you have to look very carefully at the legislation around sensitive interests, and it does effectively require that individual members make that request of the monitoring officer, and that their interest be treated as a sensitive interest. And so that's how we deal with it here at our authority. Next slide is reforms to the conduct regime. So there's been lots of review and lots of proposals for how they're going to change the conduct regime, which will require parliamentary time because they will require reform to legislation. So whether that's going to be this year, that's why I said watch this space just to see what happens there. And the next slide, just touching quickly on politics. As a monitoring officer, you're going to need a very strong awareness of the political landscape within your authority. It is obviously important to stay out of party politics, but you need to understand where issues are likely to arise and may impinge on decision making. And it certainly helps to have an understanding of the emerging national and regional policies of political groups on your council. And being able to work with elected members to achieve lawful decision making is absolutely fine, and it doesn't mean that you're not impartial or you're not politically neutral. I've put up here the publicity rules. Again, it's just an awareness that the specific legislation prohibiting the use of local authority resources for party political purposes. And again, there's specific parts of that deal with the run up to an election, which is historically been called purdah, but it's a period of heightened sensitivity. Access to information. I'm sure you all know that councillors find it incredibly frustrating when they're kept in the dark and they're not aware of what's going on within their area, and they learn about things secondhand. councillors want a no surprises approach. So that means that executive members will be expecting regular briefings in matters pertaining to their portfolio areas. Divisional ward members expect to be informed of local issues, and opposition members like the opportunity to be able to express their opinions before decisions are taken. So members have extensive rights to access information. It started with the common law principle of need to know, but there's lots of other additional rights now enshrined within the legislation, local government law legislation, as well as access rights under data protection and freedom of information. So it's just to be very aware of that. And then moving on to our penultimate slide, or our final slide, which is tips. The starting point is it's very helpful to have a good working relationship with that trilogy of statutory officers that I talked about at the beginning of this presentation. As monitoring officer, you want good relationships with the head of paid service and the chief finance officer, and having regular discussions with them as to what's going on and to build trust as a team. It's also helpful as monitoring officer, you have sufficient seniority within your organisation, so that you have visibility as to what's going on, and can command the support and resources of your organisation. I'm aware that there's a monitoring officer helpline that's been set up, and there's an association of monitoring officers that has been set up. Being a monitoring officer can be a lonely place, so building peer support and having a good network to just bounce things off, take people's ideas is really helpful. I've already talked about the emergency acts and not making the Section 5 report unless you have to. Only break that glass in an emergency if you're not being listened to. And then finally, be yourself and not what you expect a monitoring officer to be, because you need to maintain a respectful and professional relationship with councillors. They don't need to be, and they're not your friends, nor are they your enemies. And you'll need to ensure that you have rigorously seen and are politically neutral. Councillors from all political parties will confide in you, and you need to keep that confidence and ensure that you keep your own and are seen to keep your own integrity. So that's where we're at with our presentation on the role and responsibilities of a monitoring officer. We'd be happy to answer any questions if you want to get in touch with us via First North Law. Thank you very much.